Muy buenos días, señor presidente de este foro, excelencias, distinguidos miembros del grupo de trabajo, distinguidos delegados y participantes, damas y caballeros. Es para mí un gran honor poder participar esta mañana en la apertura del primer foro sobre empresas y derechos humanos. En primer lugar, me gustaría dar la más cordial bienvenida al profesor John Ruggie, ex representante especial del secretario general de la ONU sobre la cuestión de los derechos humanos y las empresas transnacionales y otras empresas comerciales, quien ha aceptado la importante tarea de presidir este primer foro anual. Asimismo, me gustaría dar una cálida bienvenida a los miembros del grupo de trabajo sobre los derechos humanos y las empresas transnacionales y otras empresas y a todos los distinguidos participantes en esta sesión de apertura de alto nivel provenientes de todos los ámbitos, incluido el empresarial y el sindical, y de grupos y comunidades afectadas, para compartir sus experiencias y realidades del terreno. Ello demuestra la relevancia de este foro, que brinda la oportunidad de interactuar con los Estados miembros y otros actores interesados en materia de derechos humanos. Señor presidente, damas y caballeros, a través de sus procedimientos especiales, el Consejo de Derechos Humanos ha venido liderando desde hace casi 10 años el trabajo de la comunidad internacional sobre la cuestión de las empresas y los derechos humanos. En junio de 2011, el Consejo aprobó por consenso los principios rectores sobre empresas y derechos humanos, elaborados por el ex representante especial, profesor Ruggie, y resolvió crear, asimismo, para el seguimiento de su implementación, un grupo de trabajo y este foro anual. Actualmente el Consejo está centrándose en el papel que debería desempeñar el sistema de las Naciones Unidas en la promoción de la agenda sobre empresas y derechos humanos y en particular la plena y efectiva aplicación de los principios rectores. En su último periodo de sesiones del pasado mes de septiembre, el Consejo, mediante resolución 21/5, acogió con satisfacción las recomendaciones del secretario general sobre la Estrategia de Naciones Unidas para integrar el tema de las empresas y los derechos humanos en sus trabajos y sobre el papel de las agencias y programas pertinentes de las Naciones Unidas al respecto. El Consejo también pidió al secretario general de la ONU que le informara en 2014 sobre los progresos realizados en la aplicación de dichas recomendaciones. Además, se decidió organizar en junio de 2013 un panel de alto nivel con representantes de los programas, fondos y agencias relevantes de Naciones Unidas para debatir en el Consejo de Derechos Humanos las estrategias que permitan avanzar en la Agenda de Naciones Unidas en la materia. Distinguidos participantes, este foro ofrece una oportunidad única a la comunidad internacional de poder reunir a todos los actores relevantes a los fines de intercambiar información sobre retos, buenas prácticas y lecciones aprendidas con respecto a la aplicación de los principios rectores. El interés suscitado por este primer foro, con alrededor de 900 participantes acreditados, demuestra la relevancia del tema. El Consejo agradece al grupo de trabajo por las consultas previas para guiar los preparativos del foro y a su vez espera con interés ver cómo estas deliberaciones alimentarán al grupo de trabajo en el desempeño de su mandato. Acojo con agrado que se haya decidido adoptar un enfoque equilibrado, centrado en los 3 pilares de los principios rectores, y que los diferentes paneles que tendrán lugar aseguren un equilibrio entre los diferentes actores interesados, así como un equilibrio geográfico, de género, y den cabida a discusiones en una amplia variedad de temas. También doy las gracias a los donantes y socios por haber facilitado la participación de diversos actores. Las voces del terreno son indispensables para asegurar que nuestros debates se basen en la experiencia concreta de todos los actores relevantes, para poder luego incidir en esa realidad, planteando buenas prácticas que resulten adaptables a otras situaciones. Les deseo entonces un exitoso debate orientado a la acción. Muchísimas gracias por su atención. Invitaré ahora al profesor Ruggie, en tanto presidente de este foro, a tomar la palabra.
Thank you very much, Madam President. Good morning to you all. My name is John Ruggie. I used to be somebody. High Commissioner, Excellencies, ladies and gentlemen, I'm delighted to see you all here. It's an extraordinary turnout, nearly 1,000 people from 85 countries representing all sectors of society here for a common purpose, to share experiences with one another on the first 18 months of attempts and efforts to implement the UN Guiding Principles for Business and Human Rights. We're thrilled that you chose to be here. We thank you for your engagement and for your commitment. I also want to take this opportunity to thank the members of the working group who have started a strong program to advance the implementation of the guiding principles, because at the end of the day, it's one thing to get principles adopted, it's another to turn them into reality on the ground, and they have an important role to play in that process. My task here this morning is to provide context for our discussions for the next day and a half. To essentially explain what the guiding principles sought to achieve and how, what some recent developments have been, and what lessons we can draw for the next part of the journey. And I'll do that by addressing 4 questions very briefly. Why were these guiding principles deemed necessary in the first place? What possessed us to spend 6 years of our life developing these guiding principles and then help persuade the Human Rights Council to endorse them, which they did unanimously, which, by the way, marked 2 firsts. The first was that this is the first authoritative guidance that the UN Human Rights Council or its predecessor body, the Commission, the first authoritative guidance that they had ever issued on the subject of business and human rights. Secondly, it was the first time that the Council endorsed any normative document on any subject that governments had not negotiated themselves. And my explanation for that is that the guiding principles by then had sufficient support from the key stakeholder groups, from business itself, from civil society, as well as many governments, that the Council in the end was happy to take the unusual step that they did. But what's it all about? Where have we come from? And where are we heading? Now, the idea that business enterprises should have human rights responsibilities that are independent of the legal requirements of the countries in which they operate is relatively new as an idea, in large part a byproduct of the most recent wave of globalization. Human rights and business became major issues on the international agenda in the 1990s. The liberalization of trade, domestic deregulation, and privatization throughout the world extended the scope and deepened the impact of markets. The rights of multinational corporations to operate globally increased greatly through, for example, more robust and enforceable rules protecting foreign investment and intellectual property. And that was all to the good. However, the protection of people in this transformed economic environment did not keep pace. Global governance gaps widened. These concerned workers' rights. It concerned issues of land acquisition. It concerned the impact of companies on sources of livelihood, on health, on the physical security of the person. History shows that stark imbalances between market forces and the fabric of societies is not sustainable. These imbalances must be rectified. Efforts to narrow governance gaps followed, including by the United Nations. In 2000, then Secretary General Kofi Annan launched the UN Global Compact as a platform for engaging the business community in support of universal values, as well as promoting and amplifying businesses' positive contributions to society's many needs. And I'm very proud to have been a key architect of the Compact, now the world's largest social responsibility initiative. But at the same time, globalization also put on the international agenda the challenge of dealing with the adverse consequences of business operations. My mandate as Special Representative was established in 2005 to address this issue in relation to human rights. It was clear to me that in a world of profit-maximizing firms and states jealously guarding their sovereignty, there would be no single or simple way of ensuring at the global level that individuals and communities are effectively protected against corporate-related human rights harm. There were two widely held illusions at the time that added to what was already a difficult challenge. One, that this aim is best achieved by seeking to subject the entire bundle of business and human rights issues into some overarching binding international legal instrument, and the other that voluntary initiatives and the identification of best practices will generate enough momentum for companies themselves to truly move markets. The problem is that neither of these approaches can deliver what it promises. The first, because it expects too much from the system of global public governance, and the second, because it permits too little. The successful expansion of the international human rights regime to encompass business enterprises must activate all the full array of rationales and institutional means that can mobilize and shape corporate conduct. And that, at the end of the day, is what the guiding principles seek to do. So how do they do that? Well, if you look around the world today, at the global level, corporate conduct is, broadly speaking, shaped by three distinct governance systems. The first is a system of public law and governance, both domestic and international. The second is what you might call a civil governance system involving stakeholders affected by business enterprises, employing social compliance mechanisms. And the third is corporate governance, which internalizes elements of the other two. In a nutshell, the guiding principles prescribe paths for strengthening and better aligning these three governance systems in support of the protection of human rights of those who are affected by corporate conduct. That's the idea behind the guiding principles. Simply put, states must protect, companies must respect, and those who are harmed must have redress. The guiding principles stipulate how. I think we will hear throughout this 2 days of discussion, including already this morning from some of our colleagues on the podium, examples of developments that have taken place since June 2011 of incorporating the guiding principles into various other international and national standard-setting bodies by businesses themselves, by civil society organizations, by workers' organizations, by industry associations, and by individual companies. Some of the examples include the new OECD guidelines, which for the first time have a human rights chapter. New provisions by Export Credit Agency to require adequate due diligence in return for public support. The new International Finance Corporation sustainability principles and performance standards, which address human rights issues much more explicitly and elaborately than ever before. We will hear from the European Union about the national implementation strategies its member states are developing. We will hear from representative of the United States government about what the U.S. is doing. We had this morning a meeting with a number of governments, including the government of Myanmar, about how the guiding principles can be applied to investment in Myanmar now that sanctions have been largely suspended. ASEAN has explored ways in which its own efforts in business and human rights can become aligned with the guiding principles, and the African Union is on a similar track. The guiding principles have also featured, as you may know, in a critical U.S. Supreme Court case, Kiobel v. Royal Dutch Petroleum, brought under the Alien Tort Statute, in which I filed an amicus brief. And so you see, across a wide array of sectors, a wide array of countries, efforts are underway to make good use of the guiding principles in order to achieve greater convergence, greater coherence, and above all, better protection for people on the ground where it matters most. We've arrived, I think, for the first time, it's fair to say, at a common platform, at a politically endorsed, politically authoritative platform for business and human rights, which provides a strong foundation on which to build. The job of building on it, of course, has only just begun. There's much to be learned from the experience already over the last year and a half or so, and the main purpose of this forum is to share those experiences, and I suspect that they may vary by sector, by industry. So let me touch here on only three broad issues that I would signal for global attention. The first concerns capacity building. Limited capacity, in my judgment, is a far greater obstacle to rapid progress in business and human rights than we tend to acknowledge. It's much easier to blame somebody than to build capacity. And yet, building capacity is the first and necessary step for making progress. Limited capacity affects the ability of all stakeholder groups, including governments, businesses, NGOs, and the UN system as a whole. The problem is particularly pronounced in relation to middle and lower income countries and small and medium-sized enterprises. Therefore, I welcome the recent decision by the Human Rights Council to explore the feasibility of establishing a capacity-building fund to promote implementation of the guiding principles, and also of the EU to develop more specific guidance for small and medium-sized enterprises. Capacity building is also ideal territory for collaborative action, both within and among stakeholder groups. But capacity building is not only a resource issue. Most companies still do a poor job of assessing and aggregating at corporate levels the costs to themselves of getting things wrong, which typically are simply rolled into local operating expenses, never attracting the attention of senior management, boards, or shareholders. Also, too many governments, as well as companies, do not yet fully appreciate how much of their own capacity gaps stem from poor internal coordination, where one unit creates problems that some other unit then has to try to cope with. So in short, the challenge here is not simply resource allocation, it is also institutional re-engineering. The need to focus on these issues is the first general lesson that I would draw for future work. A second lesson is directly related to the widespread uptake of the guiding principles by a broad array of actors. And that, of course, was precisely the hoped-for result. That's what we wanted to happen. But it also brings its own challenges. As time goes on, there is a risk that some of the coherence and the cumulative effect, the momentum provided by the guiding principles may diminish unless they are reinforced. But I believe that in our social media world, it should be possible to establish means of sharing up-to-date information in real time about major developments and trends, coupled with authoritative commentaries from time to time. Perhaps the working group, supported by the Office of the High Commissioner and external experts, could play such a role. My final observation concerns the further development of international law and the issue of extraterritorial jurisdiction. The research and consultations conducted under my mandate found that states are not generally required under international human rights law to regulate the extraterritorial activities of businesses domiciled within their jurisdiction. But nor are they generally prohibited from doing so, provided there is a recognized jurisdictional basis. Some UN human rights treaty bodies have been urging states to be more proactive. Now, governments themselves are increasingly adopting measures, domestic measures, with extraterritorial effects to help prevent corporate-related human rights harm abroad, as, for example, export credit agencies requiring companies to conduct human rights due diligence as a condition for public support. In addition, a growing number of national courts are agreeing to hear cases against companies for conduct by overseas affiliates because the company itself may have been negligent, either through omission or commission. These forms of extraterritorial jurisdiction are evolving rapidly at national levels as governments come to recognize that nothing less than the social sustainability of globalization itself is at stake. And they can't wait for someone else to deal with the challenges. But there is one area that requires more immediate international attention. National courts appear not to share a consistent understanding regarding the applicability to companies of international standards prohibiting gross human rights abuses, such as crimes against humanity. These may arise in areas where the human rights regime cannot possibly be expected to function as intended, such as conflict zones or similar sources of heightened risk. Typically, the allegations against companies involve corporate complicity in acts committed by related parties, such as security forces. Now, in those situations, plaintiffs may turn to home country courts. But even as the number of such cases has increased, courts have issued conflicting interpretation of what precisely the international standards stipulate and require. Greater legal clarity is needed for victims and companies alike, and only an intergovernmental process can provide that clarity. I therefore urge governments to consider undertaking such a process. The international community has determined, and everyone in this room would agree, that sovereignty can no longer serve as a shield behind which governments are allowed to commit or be complicit in the worst human rights abuses. Surely the same must be true of the corporate form. So let that be affirmed authoritatively and remove all doubt. My friends, my aim this morning has been to provide context. My task for the remainder of the forum is easy. It's to listen to you and to learn from you. So I'll get on with that now. Thank you very much again. And putting on my chairmanly hat, I give the floor to the chairman of the working group, Puvan Savanathan.
Honorable Chair, Madam President, Excellencies, distinguished fellow working members, distinguished delegates and participants, ladies and gentlemen. It is a great honor for me to be representing the working group on the issue of human rights and transnational corporations and other businesses at this first annual forum on business and human rights this morning. I would like to extend a special welcome to Professor John Ruggie, the former Special Representative to the United Secretary General on the issue of human rights in transnational corporations and other business enterprises, to whom we owe the development of the guiding principles which lead our mandate, and thank him for undertaking the role of chair of this first annual forum. I would also like to extend a warm welcome to you, distinguished participants of the opening high-level session, to the representatives of member states, representatives of UN systems, international and regional organizations, national human rights institutions, trade unions, business associations and enterprises and non-governmental organizations, academics and other experts. The working group particularly welcomes the high participation of business representatives from all regions in this first annual forum. The working group also recognizes that member states and business representatives both have an essential and leading role to play in the implementation of the guiding principles, which today are the authoritative global standard for preventing and addressing adverse impacts on human rights arising from business-related activity. The guiding principles provide businesses with predictability in their operations and provide clarity on the obligations and responsibilities of all actors in their different roles in addressing and remedying those adverse impacts. When the Human Rights Council historically and unanimously endorsed the guiding principles in 2011, it also established our working group on business and human rights, and this forum on business and human rights under the guidance of the working group. Let me take this opportunity to clarify that this forum on business and human rights is a body established by the Human Rights Council independently of the working group. The purpose of this forum is to discuss trends and challenges in the implementation of the guiding principles and to promote dialogue and cooperation on issues linked to business and human rights, including challenges faced in particular sectors, operational environments, or in relation to specific rights of groups, as well as identifying good practices. In its role as guide to this forum, the working group has sought the support of OHCHR to gather expectations and ideas from stakeholders for the methodology and format of the first forum. My colleagues and I on the working group express our deep and sincere thanks to all of those who participated in the online consultation early in 2012, and more than 100 participants who attended the open consultation with stakeholders in May on the themes and methodology of this forum on business and human rights. Based on these consultations, the working group's vision is for the forum to serve as a venue to foster genuine exchange among stakeholders and collective learning, including for the working group, with a focus on identifying opportunities for dissemination and implementation in all regions, as well as the experience of different actors in implementing and applying the three pillars of the guiding principles. The working group has sought to ensure that the discussions at this forum contribute to the identification of solutions to challenges in this regard, including with regard to effective remedies for affected individuals and communities. And we turn this vision into the program of the forum. The working group has engaged with external facilitators selected on the basis of their specific expertise and their stake, their vested interest in this debate. In this regard, the working group wishes to express its gratitude for the efforts and contributions of the facilitators in designing the various sessions which are within the program. With regard to participation, we sought to ensure that there is broad and balanced participation of stakeholders at this forum, including states, businesses, civil society, affected individuals and groups, and other key stakeholders in the field of business and human rights. In addition, the working group plans to work closely with other key actors in the business and human rights field to maximize synergies and to ensure that the forum outcomes build and contribute to the effective implementation of the guiding principles and the broader business and human rights agenda at the global, regional, and national levels. The working group looks forward to being able to offer its reflections on the outcome of the forum at the end of the second day, and will provide guidance and our thoughts as to the way forward for all stakeholders and for the forum process leading to 2013 and beyond. I take this opportunity, as others have done, to express the working group's gratitude to the donors and partners who have contributed to enabling the organization of the forum, namely the government of Denmark, the government of the Netherlands, the government of Norway, the government of the Russian Federation, the government of Sweden, the government of Switzerland, and the Friedrich Ebert Stiftung Geneva. These contributions will, it is hoped, enable the forum to meet the high expectations of stakeholders, particularly in promoting dialogue between all stakeholders towards the implementing of the guiding principles. Before I hand the floor to Professor Ruggie, the working group would also like to acknowledge the historic and groundbreaking role in moving the business and human rights agenda forward, approaching the subject through principled pragmatism, underpinned by rigorous research and evidence, and informed by extensive and inclusive consultation. Professor Ruggie managed to overcome decades of dogma and division and develop a framework that is both faithful to long-standing fundamental human rights norms and the principles, while also being innovative and responsive to the practical challenges and concerns of the stakeholders involved. The breadth of initiatives and activities that will be displayed during this forum, as well as the depth and scope of the thematic discussions which have been planned, are evidence of the impact of his work. The working group is looking forward to following the deliberations over the next 2 days, and we wish you a successful meeting. And before I hand the floor back to Professor Ruggie, I would like to invite you to join me in a smile. I'm smiling because I am happy that we are here, but I'm also smiling because, honestly, I'm both excited and a little nervous about what we will discover as we further open this door into the next phase of human rights. Government, civil society, and businesses working together as partners. Thank you.
Thank you, Dr. Selvanathan. We will now hear a number of keynote statements, the first of which is from the High Commissioner for Human Rights. Madam, you have the floor.
Excellencies, distinguished delegates and participants, ladies and gentlemen, I would like to join with the President of the Human Rights Council in wishing you a very warm welcome to this Forum on Business and Human Rights. And I also would like to say what a privilege it is to have somebody like Professor John Ruggie to chair this event. I know that many of you have traveled from afar, both to see him and to join in this global exchange on trends and challenges in the implementation of the UN Guiding Principles on Business and Human Rights. The value of hearing the voices directly affected or involved in the implementation process, be it from business, from government, or from civil society and impacted communities, is that our discussions here in Geneva reflect the actual challenges, good practices, and lessons learned on the ground. I am therefore delighted at the huge turnout for this event. I would like to extend a special thanks to those donor governments who made generous contributions to enable participation of a wide audience from the Global South. The theme of this year's Human Rights Day, which we will celebrate on 10th December, is Make Your Voice Count. It is about inclusion and the right to participate in public life. Your presence at this forum provides a good illustration of the importance which people from all parts of the world attach to this right. But I also see the overwhelming interest in this forum as a sign of the imperative felt by all sides, including business, of preventing and addressing adverse human rights impacts linked to business activities. The guiding principles aim to address the widening gap between the scope and impact of economic and financial actors and the capacity of society to manage their adverse impacts, including on human rights. They are a response to demands from people across the globe for higher levels of accountability from their governments, from international institutions, and from the private sector. People are demanding freedom, freedom from fear and freedom from want, as the principal responsibilities of those who exercise power. They are demanding that the rule of law apply to all, including in the economic sphere. They are demanding dignity as the central purpose of our economic and political systems. Governments must step up to close the governance gap that have played such a large part in both facilitating and sustaining the current economic crisis. And business must cooperate with government efforts in this regard. Implementation of the guiding principles will be a big step in the right direction. International human rights law, on which both the state duty to protect and access to remedy pillars of the guiding principles are based, requires governments to protect people from human rights abuse by third parties, including business and financial actors. Markets, too, must be subject to the rule of law and embedded in broader social values, foremost among them international human rights. These are not new requirements undertaken by governments. They have been part of the international human rights regime for many decades, and they are affirmed by all members of the United Nations Human Rights Council when they unanimously endorse the guiding principles, which elaborate on the implications of existing standards and practices for states and businesses. The guiding principles recognize that responsible governance requires the adoption of adequate regulatory and policy frameworks to prevent and remedy business-related human rights abuses. There needs to be a recognition also in the proceedings at this forum that enhancing legal standards in relevant areas, be it in the national, regional, or international level, may be necessary to ensure the full and effective implementation of the guiding principles. There is a particularly pressing case for such legal developments when it comes to business involvement in gross human rights abuses. Responsible business means acting with respect for human rights, reflecting the fact that long-term business prospects are tightly coupled with society's well-being. I welcome the large turnout of business representatives at this forum. We need you to be part of the deliberations and for you to share your experiences, your efforts of implementing the guiding principles. This forum offers an opportunity not only to learn from each other's experiences, but also to listen to the concerns and aspirations of stakeholders. Accountability and right to a remedy are at the core of the international human rights regime and reflected as such in both the first and third pillars of the guiding principles. However, I have noted with some concern that these fundamental issues sometimes get overlooked in the deliberations about the guiding principles. I cannot emphasize strongly enough that effective implementation of the third pillar of the guiding principles is fundamental to their legitimacy and success. I am pleased to note that the forum program includes 2 distinguished panel discussions on access to remedy. Again, I welcome the participation of representatives of affected individuals and communities who can speak from personal experience on the challenges and the obstacles they are facing in getting access to effective remedy. Having heard firsthand from people on the ground ensures that our efforts at addressing such obstacles respond to the reality on the ground. I'm also pleased to note that the working group will be embarking on a project aimed at exploring criteria for what constitutes effective remedy. The United Nations also has a role to play in advancing the implementation of the guiding principles. Earlier this year, the Secretary General presented a report to the Human Rights Council in which he recognized that it is only through the concerted efforts of all relevant actors that the potential of the guiding principles for improving enjoyment of human rights can be realized. The United Nations system has a key role to play in this regard. My office, OHCHR, will be following up on implementing the Secretary General's recommendations, which were echoed in the Human Rights Council Resolution 21/5 of 16th October 2012, particularly when it comes to addressing the need for capacity building of all relevant actors. Ladies and gentlemen, this forum is a unique space for all participants to engage on this vital human rights question in an open, respectful, and constructive atmosphere in which all stakeholders are welcome and indeed essential to our success. I thank you for embracing this approach in the true spirit of the United Nations. Thank you. Thank you, Chair.
Thank you, High Commissioner. I now invite Michael Posner, Assistant Secretary of State of the United States, to step up to the podium and share his thoughts with us.
Thank you, John. It's really a privilege and honor to be here. I want to first thank High Commissioner Pillay for all of her work in this area and more broadly. She's been a voice, continues to be a voice of moral clarity, and is a voice for the voiceless in this world. And these efforts around the issues of business and human rights is one piece of a very large repertoire of things she works on. I also want to thank the Working Group on Business and Human Rights. The fact that they've convened a meeting with so many people here is such a positive, exciting sign, and it's a reflection both of the importance of these issues and the important role the United Nations needs to play. And I want to say a special thanks to John Ruggie, who has been a real visionary in this field. He's a man who combines, as you heard this morning, diligence, intelligence, persuasiveness, perseverance, and also a real sense of practicality. And he's taken, with the guiding principles, he's moved a discussion that had many disparate parts. He gave it coherence over the years that he worked on these issues and brought us to the place we are today. John provided context, a little historic context. I want to take it even one step further very briefly. It's almost 64 years this week, in fact, that the Universal Declaration of Human Rights was adopted by the United Nations. And it was adopted at a time when the assumption was that what mattered was what governments did, and governments were speaking to each other, and they did two important things. The Universal Declaration, coming after World War II and the Holocaust, universalized rights. It says that everybody, regardless of their nationality or their status, has rights by virtue of their humanity. And it internationalized the debate, saying that this was the subject of concern to governments, and when one government failed, it was up to the system of governments through the United Nations and other international organizations to provide a remedy and protection for the people whose rights were abused. When Eleanor Roosevelt and others adopted the Universal Declaration, they had no idea that this discussion would lead in the direction we take it today. And as John said, the discussion that we're having today was amplified by the 1990s, the growth of market systems, globalization, and today, 20 years later, I think we're in a third phase where we're really trying in a practical way with the guiding principles as a justification to begin to look at how we create rules of the road, both for governments, for companies, and for non-governmental organizations operating in this space. In 1948, Eleanor Roosevelt had no idea that the world of non-governmental actors would become so important. Today in these halls, diplomats from around the world deal with the issue of terrorism, with groups like Al-Qaeda and others that have no allegiance to any state. That's part of our 21st century mandate as diplomats. They had no idea that there would be tens of thousands of non-governmental civil society organizations doing things that perhaps long ago people would have said were the domain of states. And they had no idea, certainly no idea, that companies would become, private actors would become so important in the economic sphere. Today, if you look at the largest 100 economies of the world, 50 of them are private companies. Walmart is the 23rd biggest economy in the world. And so today we come here with John and the UN's guiding principles as a framework, as John said, a common platform, which is not the end of the process. This is just the beginning. This goes beyond notions of corporate social responsibility. It goes beyond charity. It's really a question of what are the obligations both of states and government and companies to fulfill this mandate and to make it real. The work has really just begun. And when we look at this, I want to just take a few seconds to say something about what it means for governments. Governments have a responsibility, a duty, as John would say, to protect human rights, going back to the 1948 Declaration. We have to establish rules, regulations, oversight mechanisms. We have to make our courts available to make sure that the rights of our citizens and people living in our territories are protected. That's point one. And many states are not fulfilling that. So point two is we have this international obligation as states to work individually and collectively to make sure that those states that fail to protect rights, in fact, live up to those international obligations. But there's a third piece, at least for our government, which is that in some situations where rights are challenged, we need to be thinking about the obligations we need and want to impose on companies that are in our jurisdiction. And so we have, in the case of the Democratic Republic of Congo, a new law, a relatively new law, the Dodd-Frank law, which requires reporting on minerals and to make sure that those minerals are not gathered in ways that violate the rights of the people in that country. We have, in the case of Burma, Myanmar, a set of new reporting guidelines, reporting rules for U.S. companies doing business with a government in transition where there's lots of optimism, but at the same time a recognition that resources have been used to suppress rights. And fourth, I think it's important for governments to know also what not to do. A good example would be a meeting happening this week in Dubai of the International Telegraphic Union looking at how to regulate the Internet. The watchword for us is that the Internet needs to be open. It needs to be a place for free speech, free assembly, free association. It needs to be available commercially as a place for open exchange of ideas, for innovation. Governments need to know also when not to act or not to act imprudently. I want to turn last to what the role of companies should be, because essentially this is a discussion both for governments and importantly for individual companies, and so many of you in this room represent the private sector. I want to suggest 5 simple principles that ought to be a starting point for what you do, and very much in line with John's notion that we've gone from a discussion of mandated standards and laws. That was clearly, as he said, more than the system could bear. But we need to go beyond voluntary principles or voluntary agreements that don't go far enough. So the question is, what is this responsibility to respect rights? 5 simple principles for those of you in the private sector. One is that within your own company, you need to be taking stock and saying, what are the broad principles on human rights that govern your business? This needs to be taken at a senior level. If the senior management of your company is not involved, it's not going to work. This is not a public relations exercise. It's not a legal exercise. It has to do with the values and underlying principles of how you work. Secondly, you need to develop, once you've got the broad principles, internal systems that make the principles real. This requires people. It requires resources. It requires real leadership. It requires the company to say, we're going to change the way in which we do business to reflect this new reality and the rules of the road for the 21st century. Third, you need to develop internal benchmarks in order to measure your progress. There need to be metrics, as you have in every other aspect of your business. And it's not enough just to look at process. You have to look at outcome. What's the effect of what you're doing on real people in real time? You've got to measure the ways in which you are operating and how it's affecting the people within your ambit. Fourth, it's important to work with external stakeholders. So many companies say, we're going to initiate a pilot project. We're going to figure out how to do this. It simply doesn't work. There are so many lessons to be learned from NGOs, from academics, from social investors. You need to be willing to get into that discussion, however messy it may be. And fifth, ideally, you need to think about acting collectively and figure out how you can make a difference, not only individually as a company, but within your industry. And in the coming 2 days, you're going to hear from people like Oret van Heerden of the Fair Labor Association, who's worked with the apparel and footwear industries, now with Apple in the high-tech industry at Foxconn, working to figure out what are the right labor practices in the global supply chain. I commend the companies and governments that have worked with the voluntary principles on security and human rights involving the extractive industries. Companies like BHP Billiton and Newmont Mining, companies that have come to the table. There are now 19, and there are 7 or 8 governments, Australia and Colombia, are coming into the fold, hopefully. This is an effort to look at the security practices in the extractive industry, not individually but collectively. And third, I commend the companies that have come to the Global Network Initiative to look at information technology and the importance of privacy and Internet freedom, companies like Google and Microsoft and Yahoo and Facebook. And finally, in the agriculture sector, one of the things we've done recently is to look through the U.S. Department of Agriculture, mandated by a congressional initiative, to look at issues of child labor and forced labor in agriculture. These are important subjects. No company can go it alone. So I commend you all for being here. This is an important moment, but it really is a beginning. And the principles that John and the working group have put together provide a justification. We shouldn't be talking about implementation. We should be talking about how do we use the guiding principles to justify what each of us in our own communities, in our own institutions need to be doing. Thanks very much.
Thank you, Mike Posner. Our next speaker is Mr. Stavros Lambrinidis, the EU Special Representative for Human Rights.
Thank you, Mr. Chairman. Ladies and gentlemen, it's a great pleasure for me as well and an honor to be here representing the European Union. I am indeed, as mentioned, the new Special Representative of the European Union for Human Rights. This summer, the EU engaged in a peaceful revolution, if you like, in the way it restated its commitment to human rights around the world through adopting a strategic framework for human rights in which corporate social responsibility plays an important role, an action plan to apply things in practice, not just talk about them, and then appointing a special representative. And my presence here today is intended, if anything else, to underline the great importance that we place at the EU on this remarkable world gathering. Indeed, looking at the numbers, it already looks like a big opportunity. It may not be unusual to bring different groups together, but it is unusual to do it on this large scale. Now, others have mentioned this, but I feel that I have to as well. The credit goes to many, but I would like to pay particular tribute to John Ruggie for the way that he has steered this supertanker, as it were, to port. I'd like to speak particular tribute to Mike Ladeau, to Alexandra Gaiketa, to Margaret Jung, to Pavan Selvanathan, and to Pavel Sulyanjiga, because as members of the UN Working Group, sometimes we say the Working Group, but we don't mention the names. And they're almost as tough, some of them, as Lambrinidis, which is mine. But the fact is you have to mention, because they're real people who have made a huge difference with John Ruggie as well. So thank you so much for bringing as well this gathering to fruition. Now, the support provided by Navi Pillai, the High Commissioner, and her office to this work is also extremely important. And I would like to thank, finally, the core group of countries, Argentina, Ghana, India, Norway, and Russia, for the leading role in sustaining global support on this long journey. Now, dear friends, the EU is committed to making the most of this groundbreaking occasion as part of our collective efforts to implement the UN guiding principles. As Special Representative, part of my role is to enhance dialogue with governments, with international and regional organizations, with civil society organizations, with business, and with others. But many more colleagues from the European Union and its member states will also be taking part in the numerous working sessions in the next 2 days. Now, we all come from different backgrounds, operating within our own constraints. Some bring human rights to business. Others bring business to human rights. And some have worked in both fields. Now is a great chance to map out common ground. Let me give you some basic ideas that, in my view, should inform our thinking. 5 ideas. 5 appears to be the magic number. I have many 5s in my speech, and also I saw that Mike has had as well. First, human rights mean good governance for all, and that is good for business. 2, whether employees or customers, all citizens deserve the same consideration. 3, the great power of the private sector, if harnessed, can be a force for good. Businesses can change lives, and in doing so can transform societies to the better. And of course, the opposite also holds. Businesses can transform societies to the worse if that power is not harnessed correctly. 4, as in every human rights endeavor, so too in the corporate social responsibility one, the role of civil society is paramount, and governments and companies should strive for an equal partnership with civil society to achieve the results that we are all trying to achieve. 5, in this effort, we should strive for quality, quality in governance, quality in judicial systems, quality in labor lives, labor relations, quality in products, quality in the environment, quality in opportunities for women and men. These are not easy, but the big challenge, the collective challenge we have ahead of us is to achieve growth in the world based on quality, not based on inequality. Now, this session is focused not so much on principles as on moving from them to implementation. The EU is fully committed to keeping pace with the best practice worldwide, including ILO core labor standards, as underlined in our recent strategic framework for human rights and democracy. Our aim is to improve transparency along the whole length of the supply chain. One way that we are doing this is by incorporating CSR provisions in our new generation free trade agreements. In this whole process, if this whole process were easy, there would be no need for us to be here. But we have made great strides over the past few years, not least thanks to the UN guiding principles. The power of enterprises, especially large corporations, has increased dramatically in the last 25 years. The UN guiding principles offer a way to better hold that power to account. They also are an opportunity to hold governments to account for protecting human rights from violations by enterprises. They establish a global norm against which states and businesses will be judged, and are therefore key to providing greater access to victims to effective remedy, both judicial and otherwise. Now, this is why the UN guiding principles are a key point of reference to European Union policy. Let me tell you 5 things we've done. First, the European Commission is currently working on a report on EU priorities for effective implementation of the UN guiding principles, as well as other positive initiatives. 2, more than 2/3 of EU member states have already national action plans on business and human rights, or are in the process of creating them. This is good progress. This is moving from words to action. 3, at EU level, internally, we are working to improve the functioning on the internal market, making a difference to sustainable growth and employment, whilst contributing to broad environmental and social objectives. Now, some people may think that in the midst of an economic crisis, the EU would be backing off from such a difficult effort. The exact opposite is the case. Now, this is indeed a part of a general effort to make European companies more competitive, more modern, more accountable. To this end, the Commission has been looking at improving transparency and appropriate disclosure by large companies, including on human rights aspects. This is now at an advanced stage, and a legislative proposal should be announced soon. 4, we just published an introductory guide to human rights for small and medium enterprises, aimed mainly at those in the European Union. I don't have it with me, but I believe that it's being distributed out there. It's interesting. It's written in a form of questions and answers to companies. And there's one question that says, a company person obviously asks someone at the EU, says, but I operate only in the EU. Why should I be concerned about human rights? And the answer is very interesting. It says you should be concerned about human rights because you can violate in the EU human rights all the time. You can discriminate on the basis of gender. You can discriminate against particular workers, not others. You can discriminate in a way that you shouldn't against immigrants or people of different national backgrounds. So in other words, and this is the most important aspect of this, the EU is guiding itself. It is not preaching. It is determining and creating guidelines for how to deal with human rights within the EU. Number 5, the EU is supportive of the development of human rights guidance for companies and is right now moving ahead in 3 crucial sectors: oil and gas, ICT, and employment and recruitment agencies. Now, this guidance aims to be as globally applicable as possible, whilst taking account of the particular circumstances of European Union enterprises. It is critically important to us that this guidance is consistent with the UN guiding principles. Now, all 3 sets of sector guidance that I mentioned above, oil, ICT, employment, recruitment, will soon be published for comment and should be finalized by the end of April. The EU attaches great importance to promoting genuine multi-stakeholder dialogue on all aspects of our approach to business and human rights. In that spirit, dear friends, I encourage you all to submit comments on the drafts. Now, John Ruggie said that as social internet networks now allow, and indeed that is the case, for possibilities for us to discuss to each other and to share, as is important what we do. I am proud to be able to say that we are trying to go even a step further as the European Union. We encourage people to use those technologies to help us shape what we do within. And please do. In the same spirit, I and my colleagues have come to this forum in a listening mode to gather ideas and take part in a conversation. We already have a number of bilateral dialogues where corporate social responsibility and human rights are being raised, and we are looking to build on these. We are committed to working with partners to make respect for human rights a natural reflex for any business. Thank you very much.
Thank you, Mr. Lambrinidis. Our next speaker is Sandra Pulaski, the Deputy Director General of the International Labour Organization. Thank you. Welcome.
Excellencies, colleagues, friends, this forum is an important milestone in the work that the Human Rights Council has been steering on the issue of business and human rights. It is the next step in a remarkable journey for the human rights community, for businesses around the world, and for governments, with the active participation of so many stakeholders. I would like to thank the High Commissioner for Human Rights and the members of the Working Group on Business and Human Rights for inviting the ILO to speak at this opening session. It is an important opportunity for the UN and the ILO to highlight our complementary efforts in advancing respect for human rights by all actors in society. The inclusion in the framework and guiding principles of the ILO Fundamental Principles and Rights at Work, alongside the Universal Declaration of Human Rights and the two covenants, as the normative list of human rights that businesses should respect, is a strong and welcome foundation. 2 years ago, Professor Ruggie was a guest at the ILO's International Labor Conference for a dialogue with the ILO constituents from governments, business, and labor on the framework and guiding principles. Professor Ruggie recognized that the ILO has been working to advance the human rights of workers since its creation in 1919 at the end of the First World War, when we were established with the mandate, the constitutional mandate, to work to achieve social justice. The ILO sets labor standards through negotiations that involve governments, business organizations, and trade unions, and we have a supervisory system that monitors application of those standards, a system that has been working and producing results for almost 90 years. Together, we are all here today to translate principles to practice and address how the global community can ensure respect for human rights. Let me highlight how the ILO, together with its tripartite constituents, can further contribute to this strengthening of respect for human rights. To do this, I would like to quote the UN Secretary General in his report to the Human Rights Council last September. The Secretary General said, "In particular, the International Labor Organization works with states, business enterprises, and trade unions to promote and monitor the implementation of international labor standards that are part of the normative content of the guiding principles." The Secretary General went on to say, "Importantly, the ILO follows up on the ratification of labor conventions by building the capacity of governments, employers, and workers' organizations on international labor standards. It also provides enterprises with direct guidance on how to respect labor-related human rights through its help desk for business and through business-related networks." Finally, the Secretary General called for close collaboration between our organizations. There is scope, he said, for increased collaboration and coordination between the ILO, United Nations human rights bodies, and the OHCHR to ensure alignment between implementation of international labor standards and efforts aimed at promoting the implementation of the guiding principles. The tripartite structure of the ILO provides important channels to reinforce efforts involving states, business, and trade unions to promote implementation of the guiding principles. Collaboration could also include reciprocal efforts to coordinate work at the country level and to establish relations with broader constituencies. These are the words of the Secretary General, and we welcome his clear recognition of the interrelated and complementary work of the ILO, OHCHR, the Human Rights Council, and now the Working Group on Business and Human Rights. We will work together with these bodies to ensure full alignment between the implementation of the ILO labor standards and the efforts to implement the guiding principles. At the same time, the tripartite constituents of the ILO, the member states, business organizations, and labor, stress that the ILO's unique mandate to set and to supervise the application of labor standards and fundamental principles and rights at work should be fully recognized and respected by other international initiatives and frameworks that refer to these standards and rights. For example, business organizations organized in the International Organization of Employers, the International Chamber of Commerce, and the Business Advisory Council to the OECD have noted that in the promotion of the guiding principles, quote, the roles and responsibilities of different UN agencies are respected, and that the leading role of the ILO regarding all labor and social issues must be fully recognized. We want to bring this mandate and this expertise to bear in deepening and extending partnerships with the Working Group and throughout the UN system. We want to do this by cooperating more closely with multilateral organizations to promote a better coordination between their programs and activities and those of the ILO. At the same time, we want to share with them our experience in promoting rights through partnerships with business. For example, in working to eliminate the worst forms of child labor in the cocoa industry with a broad array of businesses, and working with global and local firms in the garment sector to improve both respect for rights at work and to increase productivity through our Better Work program. It is through such collaboration and joint efforts that we will together be effective and efficient in advancing respect for rights at work and the full enjoyment of human rights by all working women and men, their families, and communities around the world. We look forward to increased partnership between our organizations and with all stakeholders present here to make respect for human rights a universal and standard part of doing business. Thank you.
Okay. Thank you very much. Our next speaker is Debbie Stoddard, who is Deputy Director General of FIDH and also the coordinator of the Alternative ASEAN Network for Burma. Welcome.
Thank you, Mr. Chair. Madam President, members of the Working Group, honored guests, distinguished participants, thank you for having me here. Before I proceed any further, I would like to acknowledge the following people. Ms. Heng Chanta, a 14-year-old Cambodian girl who was killed on May 16th during a crackdown against villagers trying to prevent their land from being grabbed. Mr. Mam Sonando, who was sentenced to 20 years jail on October 1st for advocating for the rights of Ms. Heng Chanta's community. Ms. Venetia Natinga Nestor, who was shot dead in broad daylight on a public highway in the Philippines on June 19th for being a strong voice against land grabbing. Mrs. Juvi Capion, an indigenous leader, and her two sons, Jordan, aged 13, and John, aged 8, who were killed on October 18th at their home in the Philippines. Mrs. Capion and her husband, Daguil Capion, opposed mining in the ancestral domain of the Belaan tribe. Ms. Mao Hengfeng, a Shanghai housing activist and promoter of women's reproductive rights, now serving a sentence of hard labor. Mr. Ismail Solorio Uratia, the leader of a farmers' organization opposing a mining project, and his wife, Manuela Marta Solis Contreras, who were assassinated on October 22 in Mexico. Mr. Jose Tavico Zunun, a leader of the indigenous Quiche people opposing mega projects, who was shot dead at his home on June 19th in Guatemala. Mr. Aminul Haq Islam, a 41-year-old labor activist from Bangladesh, who was assassinated in April after being abducted and severely tortured. Thai conservation activist Mr. Thongnak Sawekchinanda, who was shot dead in July last year. These men, women, and children were killed or jailed because they were trying to stop human rights abuses linked to business activities. In most of the murder cases, which took place since the adoption of the UN Guiding Principles, no one has been convicted. Instead, criminalization and repression for those who seek to address the ill effects of business activities is continuing and seems to be increasing in some areas. It is imperative that this trend of repression be addressed, denounced, and halted, and that would be an incredible achievement of this forum. Although the right to an effective remedy for victims is embodied in the UN Guiding Principles, access to justice has not been prioritized. In too many of the situations I have described, those responsible have not been brought to account. Prevailing impunity makes it easier for business entities to forget their responsibility to respect human rights, which is embedded in Pillar 2. Company-based grievance mechanisms may be useful for preventing harm and facilitating resolution of minor problems. However, they can in no way replace state-based mechanisms in cases involving egregious violations. Of course, the best solution for a victim is to have access to an independent court where he or she lives. However, too often, the judicial system where the harm occurs is weak or unable to provide an effective remedy. This is why we also need to remind home states of multinational companies of their duty to protect and insist that they provide effective avenues to remedy in cases where host states lack the capacity or the will to do so. The UN Working Group could explore and recommend how home states, as part of their duty to protect, could facilitate access to justice for victims of human rights abuses in third countries involving corporations under their jurisdiction. It is a welcome development that the implementation of the UN Guiding Principles has become an issue for discussion at national, regional, and international levels. However, it is imperative that talk translates to reforms that effectively render corporations accountable and ensure access to justice and reparation for those affected. So, Before I end, let's also not forget the 34 miners who were killed in South Africa last August in one of the worst shootings since the end of apartheid, and the 2 miners who were shot dead during a wage protest just weeks ago, also in South Africa. The 5 villagers who were shot dead last August in Guinea while protesting employment practices of a mining company. The 400 workers, incidentally about half this room, who were killed in garment factory fires in Bangladesh and Pakistan in recent months. The workers at an electronics factory in China who were pushed to suicide by harsh conditions. The people I have recalled to you are dead, but their voices must be heard at this important forum. Thank you.
Thank you, Debbie Stoddard. Our next speaker is Andrei Galeev, Chief Executive Officer of Sakhalin Energy Investment Company. Welcome.
Honorable Chair, High Commissioner, Excellencies, ladies and gentlemen, it's a great honor for me to be here today and speak to the participants of this first United Nations Forum on Business and Human Rights. After centuries, finally human rights are on the list of the top priorities for society and for governments all around the world. But this has been a difficult process. In the beginning, human rights were a question of charity, then a question of public order, later a social ambition, and now, today, human rights are an obligation equally for states and for business. As it is the bicentenary of Charles Dickens' birth, one of the crucial writers on human rights, let me bring to your attention a famous quote. This is a world of action, and not for moping and drawing in. Nowadays, the great expectations in the private sector is that respect for human rights by business has to be a moral imperative. No business can be sustainable without a high social performance and appropriate corporate culture. In 2011, the United Nations Council of Human Rights adopted the guiding principles on business and human rights. This global standard brought the greater clarity to the responsibilities that business bears in society. In the business sector, with the UN Global Compact, we are working hard to move from theory to practice. With more than 100 local networks around the world and over 8,000 corporate signatories, Global Compact is a unique platform and resource for advancing human rights among the business community. As Sakhalin Energy CEO, I would like to share with you some approaches used in our company. These practices have been successful for us, our partners and stakeholders. We are proud that they were tested by experts of the testing of Effective Grievance Mechanism Program, so-called Ragi's Principles Testing Program. Earlier today, there were mentioned 5 major principles for business in human rights area. From our perspective, there are 5 critical steps to put guiding principles to practice. Looks like this is the morning of many 5s. So there are my 5s. So the first, respect for human rights should be an integral part of any business activity, and companies should have appropriate formal policies and procedures in place. For example, our statement of business principles, which is a fundamental document for Sakhalin Energy, includes respect and care for people, support for fundamental human rights as one of the core values of our company. We also introduced a separate human rights policy that defines Sakhalin Energy approach to the issues as well as the way to manage risk associated with actual or potential impact on human rights from the company's business activities. A responsible approach to human rights is also included in key companies' policies and management systems, such as Sustainable Development Policy, Code of Conduct, Policy on HSE and Social Performance, Security Policy, Contract and Procurement Policy, and others. Second, development of the policy cannot guarantee that it is implemented in practice if a full due diligence human rights process is not in place. This process encompasses allocation of resources, accountabilities, mechanisms and tools starting from the risk and impact assessment, trainings and awareness programs, monitoring, reporting, and so on. Our experience and the global practice show that it is critical to make accurate and proactive risk and impact assessment based on stakeholder engagement. The third, even in case of company has discussed and agreed with stakeholders mitigation measures, it may still receive concerns and complaints from its stakeholders. So business should be ready to address them. Mechanisms to remedy these concerns of grievance mechanism should be established and effective. Sakhalin Energy introduced such grievance mechanisms before the start of our major construction works. This mechanism is based on 3 procedures, namely the whistleblowing procedures, that's for business principles abuse such as corruption, dishonesty, etc. The human resources grievance procedures, that's for company staff, and the community grievance procedures, that's for communities and contractors. The above-mentioned company's grievance mechanism also incorporates the approaches of the guiding principles. The fourth, responsibility of the corporation to respect human rights must be related not only to business per se, but to the whole spectrum of corporate life, engagement with the outer world, relationships with all stakeholders. For example, our contractor management system includes requirements to the contractors in the area of human rights. Our contracts include special clauses to this regard. We also committed ourselves to provide training for contractors, monitoring and audit of their activities with regard to human rights. And finally, the 5. The process should be controlled by top management of the company. This should be supported by internal and external monitoring and audits. In Sakhalin Energy, this issue is dealt with by its Business Integrity Committee. This committee consists of executive directors, including CEO. Our internal and external monitoring and audits cover such areas as labor practices, security, community impacts, compensation and resettlement issues, our relations with indigenous people, etc. So, ladies and gentlemen, I sincerely hope that our experience will be of practical use for the business community. Yes, as Dickens wrote, tradesmen are not the same as they used to be. Apprentices are not the same. Business is not the same. Business commodities are not the same. So, as Sakhalin Energy CEO, I believe that neither business nor human rights are the same, because they cannot be understood one without each other any longer. Thank you. Thank you, Chair.
Thank you very much, Mr. Galeev. We had also hoped that the Vice President of Colombia would be present here this morning, but he had to withdraw for compelling health reasons on short notice. We're a little bit behind schedule. It's been an enormously rich and diverse discussion that I think has provided a good overview of the issues that are at stake. And we now have the opportunity through the various group sessions to dive into more detailed elements and share our experiences. The next sessions will begin sharply at 12 o'clock. Check your program for where the rooms are that you wish to go to. If you don't have a program, there are programs available outside of room 20. And so for now, this opening session is adjourned. Many thanks to you all once again.